So now we get into what Locke says about the form and the powers of commonwealths. And it's important to know that Locke defines commonwealth not as a particular type of government, but as any independent community. So any community that human beings create. And so then the question is, what forms of these communities do we have to choose from when making the social contract? So at the beginning of chapter 10, he says, the majority, having, as has been shown, upon men's first uniting into society, the whole power of the community naturally in them, may employ all that power in making laws for the community from time to time, and executing those laws by offices of their own appointing. There he's reiterating the power of the majority, okay? In the social contract, in effect, the majority decides, and of course anybody who really doesn't want to be a part of that contract can leave, but in a practical sense, they will decide what form of government they will have. And if they decide to retain that power within themselves as a people, then he says the form of the government is a perfect democracy. And again, so that means for those who are left, having formed a democracy, the power stays with them and the rule is still majority rule. Next he says, or else they may put the power of making the laws into the hands of a few select men and their heirs or successors, and then it is an oligarchy. Notice here that he does not call it an aristocracy, which is ruled by the wise. There was this old breakdown from Plato and Aristotle that actually Hobbes dismisses in Leviathan and other works, and Locke does not follow this division or distinction, but Plato and Aristotle distinguished between aristocracy, which they said was ruled by the wise, and oligarchy, which is ruled by the rich. Here, Locke just dismisses the distinction. Oligarchy is the only one listed, and he defines it as making laws by the few select men and their heirs or successors. And then he goes on to say, or else the power into the hands of one man, and then it is a monarchy. If to him and his heirs it is a hereditary monarchy, and if to a successor to return to them, it's an elective monarchy. And so accordingly of these, the community may make compounded and mixed forms of government as they think good. So that last reference is to the idea that you can mix the form of government, right? So you can have an element of, say, democracy, where people choose representatives, perhaps to go to some sort of parliament, but they don't choose the monarchy, which is hereditary. Or they do, and it's an elected monarchy with a legislature. So in that case, you have a mixed form of government. And so these are the choices, and he reiterates that in any case, these governments can be in continuance, or people can decide that they are revocable. That is, that the positions are not hereditary, but are revocable. So it's up to them to choose in their social contract how they will set it up, and whether they will continually choose new people to fulfill these roles, or whether they will go with a hereditary system in which people automatically become rulers based upon the fact that they are born into a particular family. Of course, that doesn't hold for democracy, the first form, because every citizen is a ruler. So next, Locke deals with the various powers of government. And the first one that he deals with is the legislative power. Locke is an advocate of legislative supremacy. He says the first and fundamental positive law of all commonwealths is the establishment of the legislative power as the first and fundamental natural law, which is to govern even the legislative itself, is the preservation of society, and, as far as will consist with the public good, of every person in it. So the legislative power is the fundamental power of government. That little clause in there about as far as will consist with the public good, when it comes to the preservation of society and every individual in it, has to be put in there because Locke realizes that conscription is necessary, or sometimes what I mean by conscription is drafting, that you have to be able to have a government say, you will fight on our behalf. Without that ability to form an army, there can be no government in his view. So it's a little tricky because, of course, Locke says that people create government for the sake of preserving themselves, their lives, their liberty, and their property. But there's this point at which young men, in particular, are going to be asked, or not just asked, but made to protect their country at the risk of their lives. And so he will talk more about that, but it's definitely a sort of problematic area of a theory like this, which is so much based on the individual's self-interest. How is it in the individual's self-interest to take up arms and risk one's life to defend one's country? Then he goes on to talk about the limits of legislative power. So even though we have referred to legislative supremacy, what that is going to mean is that the legislature stands supreme relative to the other powers of any government. The lawmaking power is the fundamental and supreme power in his view. And so what we would call the executive and the judicial functions, and he also mentions the federative function, all come under the legislative power. So Locke really doesn't have the notion of checks and balances in his system. That is more of an invention of the American founders, and in particular James Madison. There's some separation of powers, but really they flow from the legislative power. So through the social contract, the people are the authors of the laws. And so every law that is passed is presumed in that way to be the will of the people, even though in every case it's the majority that decides. But they have decided to put the decisions into the hands of the majority in a system such as a democracy or an oligarchy. If they've actually put themselves into the hands of a monarch by some sort of social contract, this becomes a little problematic because then the monarch represents all the people. The people are always the authors of the laws because they make the social contract, but you can see how monarchy doesn't quite, in a practical sense, fill the bill. And of course, as we move forward, he's going to be pretty critical of monarchy. But basically here he's saying that the legislative power, though it is the fundamental power, must be limited. And it must be limited because people would never agree in a social contract to give away so much power that anybody became tyrannical over them. So he lists 4 limits. First, he says, the legislative power cannot have arbitrary power over people's lives and fortunes. He says, it is a power that hath no other end but preservation, and therefore can never have a right to destroy, enslave, or designedly to impoverish the subjects. Okay, so we can never say that the intent of the people in making a social contract would be to create a government that thought it had the right to destroy and enslave them, is basically what he's saying. That doesn't make any sense. So since in his view government is by the people, made by the people could never make that decision. So therefore you can see his conclusion would be, and it will be later on in the book, that type of government is illegitimate and should be overthrown. The second limit, he says, is these laws that are made by the legislative power also ought to be designed for no other end ultimately but the good of the people. And so for this reason, they need to be standing laws and they need to establish known authorized judges. If the people do not know what the law is, or the law changes constantly, which is what he means by arbitrariness, If they don't know what system is in place to adjudicate, to determine whether a law has been broken and who's responsible, then basically they're living with an arbitrary and capricious government. They don't know what to expect, and that certainly isn't in their interest. And again, they would not have agreed to that. Thirdly, the legislative power cannot take the property of the people without the consent of the governed. And later on in this chapter, he says they must not raise taxes on the property of the people without the consent of the people. So there's a fundamental idea that's echoed in the American founders' notion, right? And the whole no taxation without representation cry. The idea here, though, is that a government that can take your property has the power to take away that with which you need to live, and so could literally threaten your life, and therefore, again, you would not agree to it. And the fourth limit is that the legislative power cannot transfer that power of making laws to others. So it cannot, for instance, basically submit to a foreign power that was not selected by the people making the social contract and cease to exist and dissolve itself. It has to retain the power that was given to it by the people and not give it to others. He starts out chapter 12, which is on the legislative, executive, federative power of the Commonwealth. So he's going to talk about all three. He says the legislative power is that which has a right to direct how the force of the Commonwealth shall be employed for preserving the community and the members of it. But because those laws which are constantly to be executed, and whose force is always to continue, may be made in a little time, therefore there is no need that the legislative should always be in being, not having always business to do. Maybe tell that to the U.S. Congress, right? And he continues, and because it may be too great a temptation to human frailty, apt to grasp at power, for the same persons who have the power of making laws to have also in their hands the power to execute them, whereby they may exempt themselves from obedience to the laws they make and suit the law, both in making and execution, to their own private advantage, and thereby to come to have a distinct interest from the rest of the community, contrary to the end of society and government. Therefore, in well-ordered commonwealths, where the good of the whole is so considered as it ought, the legislative power is put into the hands of diverse persons who, duly assembled, have by themselves or jointly with others a power to make laws, which when they have done, being separated again, they are themselves subject to the laws. So one great limitation of the legislative power is that they don't meet constantly, don't have to, and also that the laws that they make apply to them, which of course would create less of a temptation to abuse that power. But also now he's going to separate the executive power from the legislative power in the sense that he's going to put it into a different set of hands. Okay, he's going to make an argument for doing that. People could create a monarchy that's a hereditary monarchy with no other power, where the monarch is the legislator and the executive and the judge and the foreign policy maker and all of that. But Locke clearly is not recommending that. So when I say separation of power here, I don't mean that in Locke's scheme the executive is co-equal and separate with the legislature, but we mean that a different person holds the executive seat, so to speak, person or people. It's not the same people as the legislative power. But in Locke's system, the legislative power is still supreme, and the executive is just that. It's there to execute the laws that the legislature passes, not to make its own laws. Unlike lawmaking, which does not need to be perpetual, we do need perpetual execution, he says. Then he talks about the federative power, which he defines as the power of war and peace, leagues and alliances, and all the transactions with all persons and communities without the Commonwealth, that is, outside the Commonwealth, and may be called federative, if one pleases. And he explains that the two powers, executive and federative, do not need to be separate, that naturally speaking they're separate powers, as in they're separate functions, but that it makes sense for the executive and the federative to be joined. Although that's a bit of interpretation on my part, because he does kind of hint to the possibility of relying quite a bit on those who actually conduct these things. And it's unclear if he stands strongly for the combination of the executive and federative power. He does say the executive and federative power of every community, though really distinct in themselves, yet they are hardly to be separated and placed at the same time in the hands of distinct persons. So what he says above may simply mean that the executive needs to delegate to those, for instance, maybe in the military and in the diplomatic corps, the power, or at least the judgment, to be able to handle these things that they know the best about, but can retain power over the federative. So we can at least say the executive emanates from the legislative power, and the federative power is allied with the executive power and most likely joined to it, but with the notion that the federative power includes knowledge that can be obtained only by those who are engaged intimately with that type of activity. Then in the same chapter 13, Locke makes quite a big point of saying that though the legislative power is supreme over the other powers, namely the executive and the federative here, the people always retain the right to remove or change the legislative. And then fairly quickly he morphs into a discussion of the executive power, and really to the case of England. He says, in some commonwealths, where the legislative is not always in being, the executive is vested in a single person who has also a share in the legislative. There that single person, in a very tolerable sense, may also be called supreme, not that he has in himself all the supreme power, which is that of lawmaking, but because he has in him the supreme execution, from whom all inferior magistrates derive all their several subordinate powers, or at least the greatest part of them. Having also no legislative superior to him, there being no law to be made without his consent, which cannot be expected should ever subject him to the other part of the legislative. He is properly enough in this sense supreme. But yet it is to be observed that though oaths of allegiance and fealty are taken to him, it is not to him as supreme legislator, but as supreme executor of the law, made by a joint power of him with others. Allegiance being nothing but an obedience according to the law, which when he violates, he has no right to obedience, nor can claim it otherwise than as the public person vested with the power of law, and so is to be considered as the image, phantom, or representative of the Commonwealth, acted by the will of the society declared in its laws, and thus he has no will, no power, but that of the law. Well, here you see Locke taking quite a turn, right, in his rhetoric. So here we see his ultimate agenda coming out here. You might say he's going hard in the paint when it comes to the executive power and its limits. Locke has a penchant for writing extremely long sentences that go on and on with commas and semicolons, but certainly if you read this through, you get the gist that he is talking about the claim that the king has in some sort of position of divine right, the claim that he makes to be supreme over his subjects, and Locke is basically saying, no, he's not. The legislative power, that is in England, the Parliament, has the power, has the ultimate authority, even if it's not always in session. But the king has claimed to have that kind of supremacy. but he is simply the supreme executive of the legislative power. And he has to obey the law. That is, he is the servant of the legislature. And if he violates that law or fails to execute it according to the legislature's wishes, then he says the king has no right to obedience. So here we see the seeds of what becomes Locke's argument for the right to revolution. A little further down, he says, when the legislative hath put the execution of the laws they make into other hands, they have the power still to resume it out of those hands when they find cause, and to punish for any maladministration against the laws. So there's a very forthright statement of legislative supremacy, where the legislature can decide to remove the king, for instance, and even to punish the king for maladministration. And then he goes on to say that if the executive prevents the legislative from meeting, that is, uses his troops, for instance, to stop members of parliament from meeting, or even tries to just simply declare that they should not meet, then he says the executive is in a state of war with the people. And at that point, he says the people have a right to remove it, that is the executive power, practically speaking the king, by force. So here we have the right to revolution. It happens when the executive puts himself into a state of war with the people by not obeying the legislative power which was instituted by them. So the right to revolution ultimately stems from the people's authoring of the social contract. They are the authors of it. They set it up for their well-being, and therefore they have the right to remove any part of the government, including the legislative, if necessary, that threatens their self-preservation and their freedoms. But later on in this book, Locke is going to caution that people should be very, very careful before they decide to take these types of steps towards revolution, because revolution is a very, very dangerous and risky enterprise. Nevertheless, here he wants to argue quite forcefully that it is an inherent right of the people, and it is sometimes necessary. So from here on out, things get a little bit more heated, so to speak, as clearly Locke is making a forceful argument for the right to revolt against a tyrannical king, and he's going to make an argument pretty forcefully for a version of government that he approves of, namely one in which there's a strong legislature, but where powers are separated into different hands, but where the legislative power remains supreme, because it's closer to the will of the people. He's going to deal with regicide, if necessary. He's going to deal with the reluctance that people rightly feel towards doing such an act as killing a king, or even revolting in the first place. He's going to caution that it is a huge step, but nonetheless, this is the direction he's taking. And notice that he hasn't spent any time really discussing the forms of government that he said people could make in the social contract. Democracy, aristocracy, oligarchy, and monarchy, or mixed. In his discussion, he's kind of moved into mixed, and in particular the English version of the mixed government, and really hasn't talked about how these other forms of government could be established. So unlike Hobbes, who took those things on in Leviathan more specifically, Locke's agenda here kind of necessitates that he move forward fairly quickly into a discussion of the state of affairs as they actually more or less existed in England at that time. He has an agenda here that is not purely academic and has to do with potentially justifying the revolution. which became, of course, the Glorious Revolution of 1688, in which King James II of England was overthrown in favor of William and Mary.